All right. Mr. Reed. We need Attorney Smith. Ms. Nelson, Mr. Bridges, did Mr. Bridges indicate if he's dialing in or showing up?
He did not, Judge.
Okay.
I spoke to him. He said he's going to file a waiver, which is that
Is Mr. Reed, if I'm remembering, this predates you probably by a fair amount, Ms. Charles. He had, I'm not exaggerating, like 8 open CP cases, and they've now been indicted?
Yes, sir.
Okay, this 21 SC is that?
It's the most recent one that.
Okay, got it. All right, so you think, and I'll check the docket, that Mr. Bridges may have just in advance popped in that waiver of arraignment? Okay, well, let's see. Are there folks here for Mr. Reed? He often has family here. Okay. Is Mr. Reed here? Is he one of the folks who got brought over? Oh, he's up in Cobb?
Yeah, so they're bringing them down, but they are not.
Okay, so we'll bring Mr. Reed out when he gets here so I can give him an update. I'm going to look in the docket right now. It sounds like his lawyer has filed some paperwork that addressed what we were going to do today, but let's wait for Mr. Reed to get here. And I can't do a whole lot of talking with him because his lawyer's not here, but I'll certainly bring him out and see him from where you are. And I'll give you and Mr. Reed an update of where we are, okay? Thank you. Okay, that's right. Ms. Charles, you are spot on. Mr. Bridges filed the waiver of arraignment and entry of appearance a couple days ago. So we're good with that. That'll actually move things along. But you believe that there are no outstanding CP matters now?
When I last checked, I didn't see any.
Okay. All right, great. Well, when Mr. Reed gets here, he can come on up and we'll speak with him real briefly. Zachary Owens. You are Mr. Reed's co-defendant. All right. And is Mr. Katz your lawyer? All right.
I'm sorry. Under 18, Mr. Katz filed a motion to withdraw.
To withdraw.
Yes.
Okay. Thank you. I was just gonna, so let's check that out. We've got a co-defendant. Yes, Mr. Katz did file a motion to withdraw. So, Mr. Owens, Mr. Katz says that you or your family hired him for bond only. And this was before your case was indicted. He clearly got you a bond because here you are. But he wasn't hired or intending to represent you after the bond hearing. Do you agree with that, or you think you paid him? Okay. Are you able to hire another attorney, or do you need me to appoint an attorney?
He'll be my same attorney. I guess I spoke to.
Okay, so he filed this motion to withdraw about a week ago, but you've spoken to him more recently than that?
I spoke to him lately, so I need to get in contact with him.
Okay, do you know how to get in contact with him? All right, and I'm not trying to pry, I just want to make sure this is something that can work out for you. How, are you working, or are you, Miss?
I'm his mother.
Hello, Mom. Okay, so I figured the money was actually standing next to Mr. Owens. Are you,
I work at Georgia Tech. Every week, so today I have to go to work too.
okay. Well, we'll get you out of here in a minute, but I just want to make sure that between you and your mother, you feel like you've got the resources to pay Mr. Katz.
Yes.
Okay, when are you planning on talking to Mr. Katz?
Well, I can call him today.
Okay, so what I'm going to do is reset this for a pretty short window. We'll probably have you come back, Mr. Owens, just in the next couple weeks with Mr. Katz, or there's some paperwork he could file saying, I'm in, we waive arraignment, let's move this case along. So either he has to do that or show up with you. He can show up virtually, but be together with us at the same time. And if he's not, then I'm going to assume that actually financially he wasn't available because he wanted this much and you've got that much. You've got a right to have any lawyer you can afford, but if you can't afford one, there are expert lawyers that I can appoint. I just want to make sure your case is moving forward. So I'll give you some time to reach out to Mr. Katz and see if you can make the financial arrangements, but we'll get another date for you to be back here with Mr. Katz so we can get your case moving along. Does that make sense? That seem fair to you? All right, let me ask you a quick question. I've got as an address where we're sending mail to you, an apartment on Campbellton Road, J16. Is that mom's place?
Yes, let me ask you a question. Can you send it, we barely got that letter. Really, the post would put it in another, wrong mailbox, so they put it in our book. So lucky I got it.
Yeah.
So my question is, can you send it to my P.O. box?
Ms.
Or
Nelson,
can you send it to the address?
Ms. Nelson, does the clerk's office send notices to PO boxes?
No, they do not, Judge.
We lucky we got it.
Yeah, so you're gonna wanna, I know it's tricky with apartment complexes and the mail person's just sort of throwing things in boxes.
Yeah, open it, so lucky we got it.
Yeah, so that's all the more reason to get Mr. Katz in the mix because he'll get those notices too. And that way he'll be able to say, hey, Mr. Owens, we got court on this day or that day. Cause I don't want you to mess up your bond because the little mailboxes at your apartment complex don't work so well. But unfortunately we cannot do PO boxes. We got to send it to the J16. Are we able to give Mr. Owens a date now, Ms. Nelson, or should we just let him know that he'll get something in the mail?
If you give me just a few minutes, I'll look and see what next court date we have.
Okay, great. So if you guys will sit tight, you'll still get something in the mail, but I'll be able to tell you now what that date is so you can write it down and know this is when you'll need to be back. There's going to be a setting just like this. It'll be likely in the morning and you'll just need to have Mr. Katz with you, or he will have needed to file something like you just heard in Mr. Reed's case. He can file something where he's waiving arraignment on behalf of Mr. Owens and we can move the case along. But most of all, he needs to say, I'm not withdrawing anymore. Because right now, the only paperwork I have from him says, I'm done. I'm not Mr. Owens's lawyer. Okay? All right. So we'll hold on that. Position 6 is Carrie Henderson. Mr. Abate, it's got your name on it. Oh, because of the next case, Parks. Got it. All right. So Henderson and Parks. Is Carrie Henderson here? Hello, Ms. Henderson. I don't have defense attorneys for either Ms. Henderson or Mr. Parks.
I can, oh, go ahead.
For Mr. Parks, Judge, that would be the conflict defender's office, and I'm here in that case as well.
Okay. You are here because Ms. Bernard has dispatched you from
Yes,
her other jurisdiction.
yes.
Fantastic. This is your case, or you are representing the conflict defender's office for right now?
I'm representing the office for right now.
For right now. So it will be so that means somehow Ms. Wood or Ms. Patel have Ms. Henderson.
Yes, Judge, Ms. Patel will have Ms. Henderson.
Any reason why, I'm sorry to interrupt, but there's another one of these that just happened where Ms. Henderson, don't know what she had to do with the case, but her charges are like this. And then there's a murder charge and we flipped it around. Is it just someone got arrested first or?
I'm actually not sure how that happens.
Okay.
I know that there's a third co-defendant.
Oh,
that Actually, we just conflicted off of.
why would you all conflict off? Oh, not your call.
I have some of her notes. I know that she said she could keep Henderson because what she's discussed with the third co-defendant does not
Okay.
relate to the incident.
Oh, so in theory, your office could have come off everyone and that would have been bad, but they're going to keep Ms. Henderson.
And Mr. Abate might be able to help me. I think there's a fourth co-defendant that we do have as well, but maybe under a different number.
Oh, okay. Well, let's poor Ms. Henderson stand in there. Ms. Henderson, you are represented by the public defender's office. The public defender, the specific public defender who's going to help you is not here today, but her partner, Ms. Wood, is right here. And she's going to talk to you a little bit because I'd like to handle arraignment or waiver of arraignment if we can for Ms. Henderson.
And Judge, we can't, I apologize. I've already talked to her. We're gonna enter a plea of not guilty and I've confirmed her address.
Great.
And so I will put in the entry and waiver on this Patel's behalf.
Fantastic. Okay. So do you need to talk to Ms. Henderson anymore?
No, Judge, she's free to go.
Ms. Henderson, your lawyer, who again isn't here, it's Ms. Wood's law partner, Ms. Patel. She's going to get the discovery in the case. She's going to reach out to you because you gave Ms. Wood your info, and she'll want to meet with you soon to talk about this case and figure out how to move your part of it forward. You're on bond. You need to make sure that you comply with all the conditions of bond, okay? Any questions?
The only issue that I have is they got where I can't talk to my son.
Is your son, what's your son's name?
Parks.
You cannot talk to your son. That is correct. Now, that's a great topic for you and Ms. Patel, your lawyer, to discuss, because it may be that she, Ms. Patel, talks with this gentleman here, Mr. Abate, who's the prosecutor, and it may be that the lawyers can figure out a way where you can talk to your son, but your son is a co-defendant in this case. I don't know anything about the case other than this one important fact. Your son is charged with murder, pretty serious. I understand why whatever judge gave you a bond said one condition is don't talk with the co-defendants. That's pretty standard. What's not standard is that one of the co-defendants is your son. Usually it's friends and not talking to the other one, not a big deal. But yours is more complicated. And so it may make sense, but the prosecutor would need to agree with it, or we'd need to have a hearing. I mean, ultimately I decide what the conditions of bond are going forward. So talk to Ms. Patel about that, and she will give you some good thoughts. And ultimately she may say, Judge, we want to modify Ms. Henderson's bond so she can talk to her son. Okay, but for now, please abide by that. If I get a jail call and it's you talking to your son, that's going to be a problem for your bond. Okay? All right. Anything else? All right.
She's good to go. I'm just gonna give her Ms. Patel.
Great. All right. So Mr. Hudson, your office represents Mr. Parks.
Correct.
Okay. And are we able to handle arraignment today?
Yes.
Okay. We'll get him out here to do that. Do we know who then represents Mr. Phillips?
Ms. Patel said that she submitted a conflict on the 21st and she checked yesterday and she still didn't have an update on assignment.
Are there any C3 attorneys left in Fulton County? Who is still doing it? I know Mr. Bowles is gone, you're gone, Mr. Shepherd, you're doing other things. Mr. Shepherd is doing something different. Do you just know any inside baseball? Are there C3 lawyers in Fulton?
Pretty difficult right now to find C3s, Judge,
Yeah,
for various reasons.
yeah, okay. You don't have like a little Rolodex you can give me of C3 lawyers? Okay, from your time in the business. Okay. Well, we'll bring Mr. Phillips out and I'll let him know that we're trying to get him a lawyer, but it will not be the public defender. Okay,
Thank you, Judge.
sure. Mac Ransom. That's Mr. Melnick's client. He also often files waivers in advance. Ms. Charles?
He didn't in this case. I did try to reach him by telephone. I wasn't able to, so I must go just the address.
Okay, do you know what his CP case is?
It's,
I can look it up. If you knew off the top of your head, I'll look it up. while we-
21 CP 203327.
No, that I know. You put that on the calendar. I was wondering what the charges are, but it's disorderly conduct and obstruction of an officer. I just like to know, like that can go wherever it needs to go. His real serious charge is the indicted one. You got a carjacking charge. All right. So Ms. Nelson, if you can try to track down Mr. Melnick, please.
Yes, I believe we were holding for his report, but I'll double check.
Okay. If he knows to be here and he's cycling through other courts, I got it. Okay. Let's hear about Kenneth Brantley.
Judge, he'll be mine.
Okay,
We're gonna waive full arraignment today and enter a plea of not guilty. I have made a referral to BHTC,
okay,
and Mr. Abrams is working on that investigation. And as soon as I have an answer, Ms. Charles and I are gonna talk about the case more.
okay. Well, we'll bring him out and he can do that. 11, Braylon Brown.
Also mine, Judge.
Okay,
Ms. Charles and I are gonna speak about this case. He does have the non-complex case
mhm,
as well. And so if we could come back to this one, I'll have an announcement for the court.
okay. And that's it. Is Mr. Drain here yet? No. Okay, I don't think he's late yet. We have all these other people here. There he is. All right. Then why don't we get,
Before you move on, yesterday I received a notice from Ms. Nelson that Ms. Shaquille Scott is walking, Mr. Adams.
yeah, is Miss Scott here? She is, great. I'm glad you're here. Is Mr. Adams, do you know if he's gonna walk in or if he's gonna appear virtually
He's on his way, Judge.
on his way in person?
Yes, he is.
Okay, all right. Well, look at that. He and Mr. Hudson can talk too. All right, Miss Scott, you take a seat. And when Mr. Adams gets here, we'll talk. I think that may be a Mr. Abate issue because I think Miss Scott's co-defendant is it's juvenile, but a murder case.
Yeah, I spoke with Brian, played contact on Mr. Adams, and I didn't see this morning.
Okay, he's allegedly going to be here. Okay, all right. Then in a moment, let's bring Mr. James out. I need to talk to you for 1 second, Deputy, out in the hallway, and then if we can bring Mr. James out.
Mr. James, nobody will know the prosecution, Mr. James. Yes. I'm getting way off base. But.
Oh, on this calendar.
So he's not on the calendar, but.
I'll look.
Okay. Okay.
I'm not sure how. Like, I need to see how it goes.
Okay.
But you're probably.
Okay.
Great.
I know.
So Mr. Hudson, we'll do Mr. James first. He's first on the calendar. If you don't mind sticking around for a few more minutes in case we overlap with Ed Adams, that'd be helpful.
Take it, Mr. James.
What?
Please.
Can I just leave this one? Are you sure? Okay. Thank you. Is there a second calendar?
Just a sec.
Yes, there was a Brian Brown that is not going to go forward. He was on a probation revocation calendar. It's Ms.
Hey.
Patel's case.
Yeah, I got the email about that and I saw the petitions. The calendar wasn't in the Outlook notice, just the petitions. So that's all I know. But I think Ms. Patel wanted some more time. Was there any other case you were thinking of or just Brown?
That was it, Judge.
Okay.
She just wanted me to make sure that the court saw her request to reset.
Yep.
Come here. Oh, you can go.
Hey, Mr. Adams.
Good morning.
Should we?
Go ahead. Go.
Yeah, Mr. Adams, why don't you come on up here too, since you have some of Mr. James's cases? I just want to figure out where we're going with all this. Mr. James, Mr. Hudson represents you or represented you on this oldest case you've got from 2019 that charges you with a marijuana thing. You've got a more recent case, a 21 SC case, where you've got a different lawyer that you hired. He entered an appearance on your behalf. Let me get that case back up here. Where you're charged with some shootings, and you've got a lawyer named Robert Booker. Then you got some unindicted charges, and my understanding is that Mr. Adams, who's here, represents you on the unindicted charges. You can have as many lawyers as you want, that's fine. The one who you're not going to get to keep is Mr. Hudson. He has changed jobs and is still doing good criminal defense work, but in DeKalb County with a office there. And so he is in a position to do plea and arraignment. That's all we were going to do on your old case. It's less serious, just based on the charges, than the case that Mr. Booker has. And I don't know what your unindicted charges are. You can tell me, or Mr. Adams can. I just want your cases to try to move somewhat together. In your case where you're charged with shooting someone, we already did plea and arraignment back in September of last year, and there's a scheduling order in place, so that case is moving along. I'd like this marijuana case just to catch up and move with it. But I need to know your plans for representation. Are you thinking that Mr. Adams is taking over everything? Is Mr. Booker going to keep one and Mr. Adams has the other, or what are you thinking?
I don't have Mr. Booker no more.
Oh, okay. Well, he has not withdrawn from that case. So he's the attorney of record, and he would be the one, if I had a hearing in it, he'd be obligated to show up. He might come in and say, you know what, Mr. James and I broke up, but he hasn't filed any. Should my office reach out to him to say you need to withdraw?
Yes, sir.
Okay. And who is going to take over the shooting case?
I don't have a lawyer on that case yet.
Okay. Are you planning on hiring one?
Yes.
Okay. You know, I can appoint someone to represent you. You have a right to an attorney if you cannot afford one, but you feel like either you or folks close to you have the resources to hire an attorney?
Yes, sir.
Okay. And you do have Mr. Adams for the unindicted cases?
Yes, sir.
Okay. Well, what I'd like to do, assuming you and Mr. Hudson are comfortable with it, is at least either do the arraignment or waive the arraignment for this marijuana charge so it can catch up to the shooting charges. And then maybe what we need to do is get you back here sometime soon just to talk about who's your lawyer going to be. Get you a deadline, say you need to, if you can, hire someone by date X. And if you can't, that's all right. I mean, you can't make money right now. So you're relying on folks on the outside to help out, or you got a big old bank account with money in it. But if you are not able to hire someone, then we need to get a lawyer to help you, because you know where you're living these days. And I know these charges are serious. And so you're stuck till we get them resolved. Does that make sense?
Yes, sir.
Okay. Mr. Adams, you for now are in just on the unindicted cases. Okay. And are the unindicted charges drug charges, shooting charges, stolen car? What's the nature of what hasn't been indicted yet?
I'm going a blank right now. What the name charge?
Possession firearm.
Yeah, aggravated assault charges.
Okay. And these are just all these things are charges only. You're obviously presumed innocent in all these situations. The goal is to try to get them together, because ideally you'd want a lawyer or a team of lawyers who can sit down with a prosecutor and say, this is what Mr. James is looking at. Some of it's messy, some of it's not so messy. Can we work it out? Or maybe it should be a trial. Because until you get to that point, you're stuck. All right. So Mr. Hudson, you are currently counsel of record on the 19 SC case. Is Mr. James waiving arraignment so we can get a scheduling order in place on that? Do you need to talk with him for a second, or you already talked?
We've already talked, Judge.
Okay.
I'm gonna waive.
So he'll waive arraignment. You're then going to need to roll off the case.
That's correct.
Okay, so you, Mr. James, will need to get a lawyer for both your indicted cases, this old drug one, and the newer shooting one. So you and your family or friends are gonna need to reach out to whomever you got in mind, Mr. Adams, apparently not Mr. Booker, but someone to see if you can bring someone on board. Okay?
Yes, sir.
Any questions about any of that?
No, sir.
All right. So what I'll do is I'll work with my staff. We'll get you a new date where you'll either come here or we'll do one of those Zoom things. And all we'll be talking about is, did you line up a lawyer? And the best way to let me know that is that lawyer actually would file an entry of appearance, and they'll know what that means. But if you make an arrangement with them and they say, hey, give me $5,000, I'll file that entry. It may cost you more down the road, but once that entry, and I'm making that number up, I don't know what it will cost. Once that entry is in there, then I'll know it's John Doe or Jane Smith who's your lawyer, because that's really who I need to be dealing with, and not you directly. But you've got two lawyers next to you, so it's fine that we're talking. All right?
Yes, sir.
Mr. Hudson, anything else on behalf of Mr. James?
No, Your Honor.
Mr. Adams, anything else on behalf? You weren't here for Mr. James, you're here for Ms. Scott, but you happen to be one of Mr. James's lawyers. Anything else?
I understand it was 1:30. I was gonna be ready for that. Okay.
Okay. Ms. Charles, my thought is you hold on to discovery in this case, because if you send it to Mr. Hudson, he's just gonna have to give it to someone else. So I'll get Mr. Hudson to fill out the waiver of arraignment form. You'll remain the lawyer of record, but all we'll do is get this case alongside the shooting case. We'll reach out to Mr. Booker to see if he is agreeing that he's out of the case. And then we will see Mr. James soon, and he can let us know who his lawyer is going to be.
Yes, Your Honor.
All right, Mr. James, any questions?
No, sir.
All right, thank you, everyone.
Thank you.
Is Mr. Reed here yet?
I could call down and.
Okay, if he's not, then please bring out Mr. Parks. You're trying to leave, Mr. Hudson.
Phone's blowing up.
You get to get out of here in just a sec. How are things in DeKalb?
So far, so good, Judge.
Good. Mr. Drain, Mr. Robinson is in a courtroom a couple floors down. He sent us a letter saying, here are the things I have to do today. And we're in line. But oh, there he is. Great. He just arrived from 5F. Good morning. You can take a seat wherever. We're going to finish a couple other things, then we'll shift to this. Mr. Parks, you can come on up. Mr. Parks, you are indicted along with Mr. Phillips and Ms. Henderson, who I learned is your mother, in a murder case. Mr. Hudson, who's the gentleman standing next to you, is employed by the Conflict Defender's Office, but he's primarily in DeKalb. And his supervisor asked him to plug in today because it's all the same office, just two neighboring counties, so that you had a lawyer standing by your side. We just need to get your case moving. It's been indicted now. I need to make sure we get discovery to your lawyer so your lawyer and you can start talking about what's this case look like, what kind of motions do we want to file, things like that. You understand what I'm saying?
Yes, sir.
Okay. Mr. Hudson, is Mr. Parks waiving arraignment and ready for a scheduling order to be entered?
Yes, Your Honor.
All right, well, we'll do that. And I guess Mr. Abate should get discovery to Ms. Bernard. The way she's left it with me is that she is the point person for my courtroom and I think Judge Dunaway's courtroom for now. And so I guess we'll get discovery to her and then she'll get it to whoever ends up being here full time.
That's correct.
Okay, all right. So Mr. Parks, I will see you next after you and your lawyer have had a chance to talk about the discovery and either some motions are filed or it's time to figure out, is this going to be a trial or is this kind of case that's working out? Any questions for me?
No, sir.
Okay. Mr. Hudson, will you please make sure before you go that you filled out a waiver form, both for Mr. James in that 19 SC case, and more importantly, for Mr. Parks in this case?
Yes, sir.
All right, and when you're done, you can give those to me. Ms. Nelson's not here. I'll make sure they get filed.
Sure.
All right?
Thank you.
Thank you.
The bus haven't arrived yet, Judge.
Okay. If Mr. Phillips is there, he can come out next.
Mr. Phillips?
Hey, Mr. Phillips, you can come up to the podium. I'll be real brief with you. I'm Judge McBurney. I don't know that we've met before. Your case has been assigned to me, and we are trying to line up a lawyer for you. You met a while ago with someone from the public defender's office, I think when you were first arrested. Public defender's office also spent a little time with a co-defendant in your case, Ms. Henderson. Because they talked to both of you, they can't represent both of you. They're going to represent Ms. Henderson. So I need to get a lawyer appointed to represent you unless you were planning on hiring one. If you don't think you can afford one, then I am happy to make sure that you get a good lawyer to represent you in this case. Were you planning on hiring someone, or were you wanting me to appoint someone?
I don't know if probably, yeah, appoint someone.
Okay, well, you know what? I'm going to start with that. If down the road you decide, hey, I've got this money, I want to hire someone, you can always do that. But for the time being, I'm going to get someone appointed to represent you. That lawyer will spend a little time with you, and then we'll bring you back into court and talk about next steps. Okay? You have any questions?
No, I'm getting seen today.
Well, I don't know who that lawyer is going to be, but because you came over, I thought you had a lawyer. There was something on my calendar saying that you were going to have the public defender. But I learned from the public defender, we cannot handle Mr. Phillips's case because they've got Ms. Henderson, who is a co-defendant in your case. So I need to figure out who the lawyer is going to be, and that person will come see you. Okay? All right. Thank you.
Judge, if I might add, so there's a person connected to the case under a different CP number. If you want me to share that, I was sending it to Mr. Abadi right now.
What's the CP number?
It's 21 CP 197309.
Mr. Gates?
Yes, Judge.
And that is related because it was on the other side of the, how,
I'm not, I can't remember all the details. I know Mr. Gates is the brother of Mr. Phillips.
okay.
I know that one of our other attorneys has been working on that case. I don't know how this got so convoluted, but that is their basis for her conflicting off of Phillips.
Okay. Gates is unindicted. And you're thinking that when it's indicted, it will be sufficiently related that it would come here?
That's Ms. Patel's understanding. Judge.
Okay. Mr. Abate, any of this ringing a bell? I don't know. You may just be learning about the Phillips and Parks case anyway.
That is the position I'm in. I'm just kind of learning the facts of the case in which the defendants are indicted.
Okay.
This is the first time I've heard of, or that Mr. Gates is somehow involved, but I will find out, Your Honor and counsel.
Yeah, just let me know, because it may be, as you dig deeper into that, you need to supersede so that everyone's in the same document. I've got no idea, but thank you for the heads up.
And I'm sure Ms. Patel can make this a lot more clear than I'm putting it right now.
Okay. All right. Yep.
Thank you, Liz.
All right. We're gonna pivot for a minute, if you guys don't mind, because I had Mr. Robinson show up. I think he's got another destination. So why don't we get Mr. Drain and Mr. Robinson up here? And then I don't see Mr. Whitenauer. Hey, how are you?
I'm here, and Ms. Davis, and also Deputy we're all here.
Excellent. It takes three. Ms. Davis I met because she is going to be the body double if Mr. Whitenauer is not available. No, you guys you take a seat.
Let me just move all my stuff. Okay, thank you.
You're welcome. Thanks.
Mhm. All right. Thank you all for being here. I entered an order yesterday that addressed the 404B 413 hearing that we had last week that involved the state presenting sworn testimony from Ms. Harris, as well as a proffer in connection with the oldest of the alleged other acts. The order speaks for itself, but in essence, it allows in the 413 other act, and it provisionally excludes the other two based on everything I learned about the case from Mr. Robinson and Mr. Whitenauer. I did note that things could change as the presentation of the evidence unfolds. So I did that. In hearing Ms. Harris's testimony, I have decided that it's appropriate to revoke Mr. Drain's bond based on everything I heard about what happened after Mr. Drain was on bond in this case. I need to know from you, Mr. Robinson, if given that decision, and you previewed this already at the end of the 413 hearing, if the 413 was coming in, you wanted time to prepare what would be effectively the cross-examination of Ms. Harris, and that would be a reason for us to take Mr. Drain's case off of the February 2 calendar. Since we're all here, I just want to be able to talk scheduling, if that is still what you'd want to do.
Yes, Your Honor, that is still what I would like to do. And as I told the court previously, I'm on leave the 2nd of March to the 20th. So I would be free that 21st date. I believe that's a trial date.
Okay.
And that's what I would request.
Okay, that would give you enough time, despite the leave, to have prepared what you want to prepare for Ms. Harris. And despite the leave, you'd be able to get ready to go?
Yes, Your Honor.
Okay, all right. Then that's what we'll do. I didn't bring the trial schedule out. You're not interested in that intermediate date. Tell me your leave again?
March 2nd through the 20th.
Okay, because we published a second calendar, but that one won't work for you. There's a senior judge who's going to come in and handle some cases the second week in March, but you've got to leave. All right, so then you'd use my date at the end of our 3 trial cycle.
Yes, Your Honor.
Okay, all right. That's what I just needed everyone to be in here. This wasn't something that made a lot of sense to do when Mr. Drain was with you in your office. And I also hadn't processed everything I needed to process from the presentation of the state side of the 413 motion. Anything, Ms. Davis, Ms. Mack, in connection with the Drain matter?
Yes, Judge. So we wanted you to know that while preparing Mr. Drain's case, we learned from Deputy Winfrey that there's a human trafficking defendant that hasn't been indicted that is related to this case. We anticipate that before the trial calendar, the dates that you gave, that this case will be re-indicted to add the human trafficking defendant. And they will all be in one indictment.
Okay, just so I get a little context, Mr. Whitenauer, in sort of giving a proffer of the case in chief, described that the way Mr. Drain allegedly met, is it Ms. Brown, the victim in the case in chief, was through Backpage, but Mr. Drain was dealing with not Ms. Brown directly, but I guess who you are saying will be the new co-defendant.
That's correct, Judge, and we didn't learn that until after he was preparing the case for trial, and he had some questions, and he got with Deputy Winfrey. That's why I brought her.
Sure.
We essentially
Right, because
learned-
that's her space. I mean, right, got it.
Essentially learned that her an indicted, well, human. Yes, I got you, that's two cases. She has two cases with this defendant, the unindicted and then trafficker.
Not Mr. Drain, but
Right.
I'm gonna say pimp for shorthand.
And let's say
Okay,
that
all right.
sure, and learned that it was the same victim in Torres Drain's case as it was in her pimping
Got it.
case. So
Okay.
it will essentially be indicted together to include the buyer, which would be Torres Drains, and the pimp.
And I'm okay with this. I don't do a lot of human trafficking work, so I'm all right with that part. But yeah, does that mean in theory there would be charges against Mr. Drain? Certainly there'd be charges against Mr. X. But then also, as Ms. Mack was saying, as the buyer, the purchaser, the John, there are human trafficking charges that can appropriately be brought against, in this case, it would be Mr. Drain.
That's correct, yes.
Okay, all right. Well, what we're going to do for now, just so Mr. Drain and more importantly, Mr. Robinson can plan, we will tentatively have this case ready to go on the week that works for you after your leave. I'm not going to delay trial if the state has not reindicted. That's not Mr. Drain's problem. But if there is a reindictment, then we will certainly need to consult with you, Mr. Robinson. I assume you will say, I don't want to go forward, not enough notice, new charges, need discovery, may need severance, all that kind of stuff. So that's very helpful heads up.
If I may, Judge, just for your information, there is another case with the same exploiter or trafficker or pimp that is indicted and is indicted in Judge Ingram's courtroom. So again, depending on how the cases come together, because there's about 3 more cases, depending on how they come together, and I should feel safe, it'll go to Judge Ingram, but I just want to give the court that.
Got it.
As well.
That's interesting. I guess she and I may have to arm wrestle as to where it may make sense for them all to be in one place, not because of Mr. Drain, but because of the exploiter. So that one judge is supervising all of that, which unfortunately means Mr. Drain gets pulled in one way or the other. But okay, a lot of moving parts. The important things for Mr. Drain, most of all, bond being revoked right now. But 2, these things you're hearing are not going to be a reason to delay Mr. Drain's trial. So Mr. Robinson will be ready to go on our final trial week of this calendar, and the state will be expected to go. Even if Mr. Whitenauer is on leave, we've got Ms. Davis and she can manage this. But that will be the plan. And we will see how all that plays out. Mr. Robinson, when you're on leave, will you be getting emails from time to time, or are you going completely dark?
I will be getting emails.
Okay, good. And I say that not because I expect you to do any substantive work, but I'll be wanting to get your input. If all of a sudden there's a new 100 count indictment, which Mr. Drain is this piece, you certainly need a chance to say, all right, there's not going to be a March trial. That doesn't make sense. And there's now this Judge Ingram wrinkle, in which case I may not have anything to say about what's going to happen. All right. Anything else procedurally from the state?
Nothing from the state, we just wanted to let the court know.
Okay, I very much appreciate that. It's well received, and now I know what to expect when 9 lawyers come in instead of Mr. Whitenauer. Mr. Robinson, you can certainly have a chance to talk with Mr. Drain in just a moment, but anything procedurally from you?
No, Your Honor.
Okay, thank you, everyone.
That's what you're saying, you want to give the family loan. Personal property.
Yes, oh, no. Like going.
Thank you, Mr. Robinson, for coming by.
All right, thank you, Your Honor.
All right. Did Ms. Wood? You're still here, Mr. Hudson, which is great. Was there something you needed from me? I didn't mean to keep you.
I'm just filling out. these.
Oh, good. Okay. Take all the time you need. I just want to make sure. All right. Let's see. Do we have an update, Ms. Nelson, from Mr. Melnick?
I just reached out to him. Let me see what he said his ETA is.
Okay. So Ms. Wood, we could bring Mr. Brantley out now to do his waiver and just say hi to him. Does that work for you? Okay,
Perfect, thank you.
great. Deputies, whenever you're ready, we can bring Mr. Brantley out.
I'm still with privilege, so you can bring him out. What's his name, Joe?
You're done? No, Brantley.
Bring him out. Let's go.
Your Honor, when this stop shows up, I am just right outside the courtroom.
Okay. How do we,
Melnick, I'm sorry, Judge. Melnick should be here in about 10 minutes.
in person or virtually?
I believe in person, he's in Judge Ingram's chambers now.
Okay, great. We'll hold on him. How do we let you know when we're ready to do Ms. Scott?
Mr. I'll be right up here.
Okay, great.
Thank you.
All right, we are almost ready for Ms. Scott. We got 2 arraignments to do, and then we can do that. Or we want to hold off on Braylon Brown because you two are going to talk more?
Yes, Judge.
Okay,
Yeah.
that's fine.
You want the podium or the table?
Whatever works, Ms. Woods, you just sit with you or you want to go to the podium?
You can sit here, Judge.
Okay.
How you
How you
doing?
doing? Great.
Good to see you again.
Hey, Mr. Brantley, I'm Judge McBurney. How you doing?
Doing great, sir. And yourself?
I'm doing all right. I just wanted to introduce myself and let you know what we're doing today in your case.
Okay.
Ms. Wood, your lawyer is going to waive arraignment for you, which just means you're saying not guilty and you want your case to move forward. She also told me that she has been working with folks at our accountability court, the behavioral health treatment court, and seeing if you could get into that program, which is a great program. And if the state agrees with that, and I think it's a good idea, that may well be how this case works out. I'll tell you that the nature of the charges make it a little more complicated for them. They're going to need, the folks at behavioral health treatment court, need to make sure that it would be safe for you and the people around you for you to be in BHTC. That's often folks who got picked up on drug charges, but have some other issues they're working through as well. Your charges are a little different, but that doesn't mean it's not going to work out. So Ms. Wood will work on that. Has someone come to talk to you yet from BHTC?
No.
All right, that may happen, and Ms. Wood can tell you more about that, but there may be what we call an intake interview, and I encourage you to speak freely with those folks because they're just trying to figure out what kind of help you need and whether they can provide that help. In the meantime, we'll move your case forward and make sure that Ms. Wood gets all the discovery, police reports, body cam video, whatever there may be in the case, so she and you can talk about it. Any questions?
No, sir.
Ms. Wood, anything else in Mr. Brantley's case?
No, Judge.
Ms. Charles, any worries you've got about discovery?
No, Your Honor.
Great. All right. Thank you, Mr. Brantley.
All right. Thank you. You do the same.
When I do it, yeah, I'll go do that. In fact, this is, I think, well, let's do, if we could get Mr. Abate is going to say, why didn't you just keep me in here? But if we could get him in here, we're going to hold on Mac Ransom because Mr. Melnick isn't here yet. And we're going to hold on Mr. Brown because the lawyers are going to talk. And that's all I got. So let's do Ms. Scott. And Mr. Reed, when he gets here, we'll do that. And why was I making you all stick around?
To get a court date.
Oh, right. Let's see if Ms. Nelson got that. And if she didn't, you should go and just check that mailbox. But let me see. Ms. Nelson, did you get a chance? I know we've been moving quickly to see if there's a date that we would get Mr. Owens back here to tell us whether he got a lawyer or not.
Yes, I put it in the instant. March 15th at 9:30.
All right, March 15th, 9:30, same place. Okay, March 15th, 9:30, Ides of March, right here. We'll see you guys then. Oh, look at that. All right, be safe.
Thank you.
Good morning, Your Honor. This is Attorney Bridges for Mr. Reed.
Hey, Mr. Bridges, I found your, Ms. Charles told me it was in there, your waiver of arraignment. All we're doing with Mr. Reed now, he is being housed in Cobb County in the overflow space.
Yes, Your Honor.
His bus hasn't made it here yet, but he's got family here as he always does. And so I let them know that I would bring Mr. Reed out to let him know you've already done your piece of the work by filing the waiver of arraignment. We finally have all his cases in one place.
No, Your Honor, we don't.
Oh.
We don't. I spoke to the DA already about this. For some reason, they indicted only 3 of the burglaries, and they left, I want to say, 4 burglaries remaining unindicted. Well, I brought that to the DA's attention last week when I talked to her.
Then I'm glad you joined us because I remember there being a large number of unindicted a bunch of CPs, and here we got an indictment, but it's not all of them. So that's confusing. All right. Well, we still need to move this case along, and I guess Ms. Charles has a little bit of homework. This predates her, so she's having to probably figure out what Ms. Hall had jotted down. But Ms. Charles, if you would please make an effort to see what your office is doing with the other CPs. I don't know if there's some connection the state believes between Mr. Reed and Mr. Owens because they're co-defendants. And so maybe they were indicted because the theory was those two operated in concert. And maybe there's some that were just Mr. Reed, but my recollection is what Mr. Bridges is saying, that there were like 8 and this doesn't include all 8. Okay. All right, Mr. Bridges. Nonetheless, when Mr. Reed gets here, I'll let him know that some of his charges have been indicted and we'll get those moving. You're welcome to stay on the call. You don't need to. I won't be engaging in any substantive discussion with him. And you've done what you need to do in connection with this subset of charges by filing your waiver of arraignment.
That's fine, Your Honor. I'm actually in court in DeKalb, so I need to go back there.
Okay. Thank you, sir.
All right. Have a good day.
Bye. Yes. All right, Mr. Adams and Ms. Scott, if you come up to the podium, please. Thank you so much. Good to see you. All right. So, Ms. Scott, you are a co-defendant with, I'm pulling this case up again, Mr. Watson, also known as Pawn. His charges are real serious. Yours are less serious, but you got a bond and an ankle monitor and all that, and then we had court and you didn't show up. So I'm gonna let Mr. Adams do the talking on your behalf. But I signed a bench warrant in September because we didn't see you in June, which was only a couple months after you got that bond. So you should not have been hard to find, ankle monitor and all. But I'll hear Mr. Adams out, and then I'm going to hear from Mr. Abate as to whether he thinks you ought to stay on bond, if we ought to modify that bond so that you are easier to find, or if I ought to enforce the bench warrant because you didn't come to court when you were supposed to, and it really wasn't all that long after you got your bond. So we're not talking about, oh, it was 2 years and you moved, et cetera. Mr. Adams, tell me about Ms. Scott's situation.
Yeah, no, she got out of prison, I believe, in April, and she's worked ever since, doing real well. I did not notify her about a hearing. I talked to the bonding company. They did not notify her about a hearing. And my understanding, when she got out, she had basically was homeless, and she said she went to the bonding company and they never notified her. She went every week, I believe, or every month. So,
I'm just looking at the bond. I don't know who the bond is through. It doesn't say, but Miss Scott, a $40,000 bond. But that's when it was a CP case. It's interesting. You ended up not getting indicted for exactly what your bond was for. So the bond doesn't quite fit the charges. But anyway, keep going, Mr. Adams.
and if she would like to speak to the court, maybe explain it a little better than I can, and the court would be willing to listen.
Okay. Let me just look at one more thing. All right. So, Ms. Scott, let me ask you a couple questions and then you can tell me what you want. I've got an address in the system for you on Cleveland Avenue. That's not your address?
I got put out.
Okay, that was your address when you got your bond.
And I got put out because I was in jail because of the case happening around my house. So
Yeah.
I got put out, and when I got out of jail, they didn't give me no paperwork. Nobody gave me nothing. The only thing they did is put this on my leg and told me I got 3 days because I told them they were finna send me back to jail because I didn't have an address. But I said, sir, I lost my apartment.
Do you have an address now?
Yes, sir, I have one, and I work. I give you my work address, and yeah.
Okay, but I'm good. I'm glad you have a work address. Do you have a home address as well?
I don't have, that's not my home. The Hope Atlanta helping me now.
Okay.
Hope Atlanta helping me. I go February the 2nd to get my place, a voucher.
Okay.
But no, I don't have a home.
Well, and I didn't mean it that way,
Yes,
but
sir.
you have a place, like if someone says, I need to mail something to you, Hope Atlanta has given you an address where mail can get to you.
Yes, sir.
Okay, all right. And where are you working?
I work at MIS on Food Industrial. It's a warehouse packing and picking, and I drive forklifts.
You're a forklift driver?
Yes, sir.
Do you have a certification?
Yes, sir. I didn't know that. I didn't even know about court. I didn't know I had court. I came to the courthouse myself.
Okay.
And I tried to check and see that I have a court date because I'm trying to figure out why nobody ain't said it. And she said, I got a warrant. I'm like, huh?
Well, because we were mailing things to this Cleveland Avenue address. But
I got out of jail. I did buy a P.O. box, but Miss Nell, I talked to Miss Nell. She said,
yeah,
no.
We don't mail to P.O. boxes. How long have you been working at MIS warehouse?
Since I started working in July. I started working in June or July.
Okay. So 6 months?
I've been working
at least.
6 months.
Okay. Are you full-time or part-time?
Full-time.
Are you there through a temp agency or you are?
First step.
Okay. Are they talking to you at MIS about bringing you on full-time or they're fine keeping you through first step?
Yeah, I can go on full-time. I ain't trying to get on with the company yet because, they get paid every 2 weeks. I don't like that. I like to get paid every week.
But don't you get benefits if you go join them full-time?
Yeah, you do. But right now I ain't stable to be I need it every week.
Okay. And tell me about this housing. You think in February you'll get your own spot?
February the 2nd, graded, because I'm mental health. Me and my kids take medication. So February the 2nd, I got to go to 10th Parkway, graded, staffing. I got to get evaluated, and then they're going to get work on with me to housing. I did my my assessment with Hope Atlanta and Gateway. So I passed that score to 6. So I passed that.
So currently Hope Atlanta is providing temporary housing.
Yes, sir, I have one.
Got it. And you said kids. How many kids do you have?
I have 5, but I only have 3 in my cousin.
3 are with you? What are their ages?
One of them is 12. No, he just turned 13. My little girl, she is 11, one on 10.
Okay. And then are the other two with dad or with family members or just foster?
Yeah, they with family.
Okay.
8-year-old and a 14-year-old.
All right. And your 3 kids stay at the temporary housing you're in.
Yeah,
It's designed for kids too.
Mhm.
Okay.
They in school right now, but yeah.
Okay. Got it.
And the bonding company finna email Miss
Nelson.
Nelson. Yeah, they got the fact number because she don't even know about it, and I pay her every Thursday.
You're still paying the bonding Yeah, it's not in the system at all.
I pay her. I go to bonding Alfred Bonding Company.
Okay. Yeah, they need to get the bond in the system because it doesn't
Yeah, I
show
pay
up.
every Thursday.
Okay. All right. And the co-defendant, that's not a relative of yours?
No.
I'm not asking about the facts of the case, but there's this kid that's not,
I went with his sister.
what does that mean?
I went with his sister. That's it.
Okay.
We went together.
Okay, like you guys were dating, you and his sister. Okay. Anything you want to add, Mr. Adams?
No, y'all, I sincerely believe she was not willful in this court, so we've asked her.
So, Mr. Abate, I very much want to hear your perspective on this. I'm curious about what the ankle monitor's for if we couldn't find, that sort of seems to be why we have ankle monitors, is that if someone missed court, then the company could say, well, Ms. Scott is at wherever she's living.
Great. When the bench warrant, I guess, was requested, I didn't make the request. I didn't even know she had a bench warrant until Ms. Nelson did send us all an email.
Saying that she's coming in.
Yes. And
Okay.
I would, had I known about the bench warrant, I would have called A&A, all county monitoring to determine where her location is. I was looking in the Odyssey system. It appears that she received notice to the Cleveland address and it was returned to the court, so she was never actually given notice according to Odyssey. And then I'm about to email your honor as well as Ms. Nelson and Mr. Adams. I went to the jail screen and was able to find the information that's pertaining to Alpha Bonding Company, who she is on bond or who paid the bond.
Yeah.
I will send that to the court and everyone else. I don't have the state would request that the bench warrant actually be set aside based on all the documents that I've been able to find
Okay.
the last couple of days.
Okay, I appreciate the candor, and it does sound like that's consistent with what Ms. Scott is saying, that she got out of jail and immediately fell into a housing crisis, not at her old address. Going forward, Ms. Scott, because things can happen. You could lose your job, who knows what. If your address changes for any reason, you got to let Mr. Adams know, and you have Ms. Nelson's number. Tell Ms.
Yeah, I got Ms.
Tell Ms. Nelson, saying, you know what, I moved. Here's my new address. It's Mr. Adams's job to keep that paperwork current, but Ms. Nelson at least can help. And that way we'll know, hey, we need to send things to this place to make sure the case is moving along. Am I correct, Mr. Abate? This is a county funded ankle monitor. Ms. Scott's not paying for it. We are. Okay. So A&A would have gladly told us where Ms. Scott was, that just no one was asking. This wasn't your case at the time. I mean, this really wasn't on anyone's radar, so to speak. Okay, yes, ma'am.
They just changed it. They just came and changed it.
Okay, but you still have one.
Yeah, I still got, they changed it because the charger went out.
Okay.
And in all candor, the board had there been something wrong with the ankle monitor, I would have been one of the lucky ones who would receive an email.
So I've heard. Okay. All right. So is the thought, if I go back to the bond had the dollar amount, which Ms. Scott has made. And she's not supposed to have contact with the victim's family. And what else? No contact with Mr. Watson, that's the co-defendant. You've got a curfew except for work, medical appointments or court appearances, and no weapons. All right, I mean, those seem like pretty standard conditions. Anything you want to modify about that, Mr. Abate?
No.
Okay, I think we'll keep the ankle monitor for now. I don't know that it needs to be there forever. This case may not move real quickly because the charges against Mr. Watson are real serious. And we need to figure out what he's going to do with all that. Let me see who, I think he's got the conflict defender, so that's going to go particularly, that's going to go particularly slowly. So we'll revisit ankle monitor if it becomes a problem. But I'll just reinstate your bond. We do need to get a good address for you, meaning where you are now. And I heard you, hey, I'm moving in a little bit. So what are you going to do when you move?
They helping me with a voucher, and it's gonna be a 3-bedroom voucher. So I'm just gonna try to get by the job, like Cascade area. But I will let Mr. Ed know him in there.
Yes, exactly. When you move, wherever you go, I hope it's a nice place with room for you and the kids. Got to let Mr. Ed and Ms. Nelson know what your new address is, so we get it in the system.
Yes, sir.
What is your current address? Actually, we need to have a change of address form. So if Mr. Adams could fill that out, then we'll get that in the system.
I can't get.
No, you don't. Mr. Adams will grab it, but there's one on the little counter there. There are a bunch of different forms, and one of them is a change of address form. Thank you, Ms. Charles.
I can't get his number, could it?
Pardon?
His number.
You don't need his number.
Oh, okay.
Mr. Adams would call him.
Okay.
Mr. Adams would say, please don't call him.
Oh, okay.
All right, so here's how we'll handle it. I will set aside the bench warrant. And when I get your good current address and make sure what Mr. Adams writes is the correct thing, whatever your current address is, and then when you move, you got to get us that new address.
Yeah.
Okay.
Can I
You
get
say you
my
will.
number down?
Pardon me?
My number too?
Yeah, go put down all that stuff on there.
Your Honor, can I step up to address my bond matter?
Yeah, I think we're done, unless you had something else.
There you are.
All right, good luck.
Thank you.
Mr. Melnick,
Morning, Judge.
good morning. We can be quick for you. We were just holding on Mac Ransom. Still your client? Great. It's just plea and arraignment. I just didn't see a waiver in from you, so you needed to be here and we were going to bring him out. Is that all right?
That's fine, Judge. I had filed a motion to reduce bond in this case. It was filed, I want to say, Wednesday or Thursday of last week. So I know Ms. Nelson had said on an email about the possibility of doing that today, but I wasn't sure what the status of it for today.
All right. He has a CP case, but that one, he already has a bond, as he should. Let me see what we got here, Mac Ransom. I see, there it is. Ms. Charles, are you in a position to argue the motion to reduce bond? I'm sorry, you can finish with Mr. Adams. No, take your time. Yeah, I need it, and I'll file it. Sure, or you can give it to the deputy, either way. All right, thanks, Mr. Adams.
Thank you.
Thank you. Is that G106?
Yes, sir.
G, okay.
Yes, sir.
All right, thank you.
Yes. Okay, Judge, can we talk for a minute?
Sure, why don't we do that?
You want us to go down and check on the other bill?
Yeah, why don't we see if Mr. Reed is here, and if he is, I'll leave the bench. And let me know when Reed is here, because we can bring him out. He's got family here. And then I had a call at 11 that just went away, so I'm good. So when you're all ready to talk about Brown, we'll talk about Brown. When you're ready to talk about Ransom, we can talk about Ransom. And just let me know, please, when Mr. Reed is up, because I'll come out and do that while they're doing their other things. Thanks so much.
Thank you, Judge.
Oh, and I need to get you guys a copy of the, because He was like, "Hey, where's my?"
Oh, yeah.
I'm sorry about that.
Sorry.
I know. So I'll go do the revocation order for drain. All right, thanks.
So, you see him do it right here. If not, you know.
I tried on your side. I was like, well, maybe, well, maybe he got a special code.
No, that shit, you can't even log in.
I logged in on your God computer.
Okay. Wayne.
Yeah, but I was like, well, maybe you got, I was like, maybe. But just now, because he was like that vision. Oh. Because even if I could send it somewhere, like it's a PC. I'm still hoping that I'm doing it. What's our computer like this or something?
Security, I know exactly what he wants. I don't know what these ships though.
Alright, well, it's done, it's just I can't, I don't know how to do it.
Well, you can go upstairs or if you want to.
Yeah, I did it. I did everything. I just changed this right here. So McBurney, Barney vote 0. This position where we put their method. I can't do it. Okay. Tattoos.
He had no driver license?
He gave everything else. Yeah. I did all the case, the name, or AG.
Yeah, go back, we can take it down and then we're gonna do it up and then do this.
Like always, I got it. Oh, I'm on 8. I don't have no key either. Huh? What? Making sure I'm going right up, right back down.
Are they all up, everybody? Are all the inmates up?
We're going to do that, man. Everybody else is still on there.
No, I can't remember what the policy is. Can I talk to them? Or
Yeah,
you
let me
guys-
put my thing up now.
Okay.
He's not here.
Thank you.
I don't have a key though. She just left.
It's fine.
You want to talk to his door?
We can just wait because I need to, she needs to give me an offering.
Okay.
Thank you though.
Oh, I'm sorry.
You're okay. I just,
Legal assistance, we just downloaded it today.
Please.
And what we'll do, we'll leave it on the third floor. What did you?
It's not, for some reason, it doesn't interact well with Maxwell. Yeah. And,
I won't go ahead and give me a drop off.
yeah, if you want to. And,
And that's easier for you, I would.
that'd be great, please. Do you, I mean, so do you know anything about the videos at all?
I don't text them. Yeah, so I think it's been working, what I've seen so far.
Thanks.
Nothing is like really like jumping for me.
Gotcha.
Just get back.
I really want to see the Kroger video, the initial video. And then, yeah, but really, they're probably all pretty simple. Oh, careful.
So we have 911 call and 1.
Okay. Yeah. Thanks.
Just let me know whenever you're ready.
I'm ready.
Okay.
I thought she was in this.
I know. How are you?
Good, how are you?
Oh, yeah. Oh, yeah.
Yes, together to that. Or. Well. I'm gonna tell you, yes, a little bit that you want to go to the podium and then this. Okay. I haven't talked to you, nephew. That's ultimately is up to him. Even though y'all, man, you know what? So. How close is it to folks real? Yeah, probably.
July 12th. Yes, I'm saying it's July 12th. So we got so.
So do it turn at the time.
So it's not July 12th. So we moved the date. Yeah, it's not really long. Okay, it's July 12th. We can't for long. that we need to let you know, this person know this case, this right to be the last. What's the policy? He's just not. I'll just grab this and you got 4 more days. But that's, we just, I mean, we've been placing them.
No, it was like that, so,
Yeah.
You know what I'm saying? Like, we don't want to do what you're supposed to say.
And yeah.
Yes. If you're a lot of the entire population. Oh. But we're supposed to embrace that, so.
The man taking me reverse.
What was
No. He just was there today. I ain't doing this background, y'all. That's what he did. So he's just letting me say, y'all know. And she's very good, like sending me emails out of her firm, like if she has everything she needs or if she's missing. Which is like, so yeah, there's just amazing. I'm gonna call it. Absolutely. Hey, everybody's saying that to you.
Okay.
So, let's have a trial calendar next week.
He has one, the 2nd, the 16th, March
And then
1st.
sometime in March.
Yeah, he's
right?
got 2 in March. And
Two in March. Okay.
we just got notice on Friday of a March 1st calendar, and then there's already,
I think March 16th, because I
Yes.
had a case on
Yes.
that calendar.
okay,
So we let it out like last week. I think.
okay,
So my case is done.
Yeah.
Because I was like supposed to be the first one out on one of those calendars.
Yeah.
So y'all were thinking,
okay.
you go to trial.
Okay, good, thanks for the heads up.
So they are definitely having jurors. for them next week.
That's the rumors.
Yeah.
So I guess we'll see.
I mean, unfortunately, like the numbers are the highest now that they've literally ever been.
Right.
In the whole course of the pandemic.
Mhm.
So if they bring in jurors next week, it really does make you wonder why we have to shut down. for
Exactly.
8 months. Yeah.
Exactly. Yeah, totally agree.
I mean, I wasn't opposed to it, I will tell you.
Mhm.
Being in my office all the time, taking every single phone call.
Right.
I was, it was nice, but I also get that all good things shall pass. right?
I know. What county are you primarily based in? Fulton? Do you take cases in the other counties? Okay. Let me keep that in mind.
Cab, Cobb, for that.
Okay.
Clayton, some, although, you ever been to Clayton County?
Oh, no.
So the one thing I will say, logistically, it's actually one of the best designed courthouses I've ever seen.
Really?
It really is. So the courthouse and the jail are connected to one another, which, I saw that they're commissioning a study for a new jail in Fulton County, which they desperately need. If they build a new jail, they really need to build a courthouse attached to the jail. And that way. Do you see those buses that they transport the inmates in? The fact that it's like never broken down and you've got inmates all over the place shocks me. Their school buses from like the 1970s, literally. Yeah, right. They're these old, rickety old school buses that they've just kind of retrofitted, yeah. And every, I think it should be that every county jail and courthouse should either be connected or placed close enough to one another where you don't have to transport inmates on public roads. It just makes sense.
I know. Carroll County has like all of their like master stuff is like right there.
Yep.
Yeah.
Forsyth County, everything is in downtown Cumming. The jail is right there. They've got a tunnel between the jail and the courthouse.
Wow.
Yeah, and they just walk the inmates back and forth. So if you until you have somebody who misses a court date for something stupid, like possession of cocaine and get picked up, you can call the DA's office, say, hey, it's a 2-year probation case. You can bring them over the same day, literally the same day. And get them let out. I've done that in Cleveland County before. I've never done it in Forsyth County, but I've literally done that in Cleveland County.
Wow.
It makes me look good. It helps to move things along.
Right.
So from that standpoint, Clayton County Courthouse is really, it's great. They also have, like if you're an attorney, you get a little security card and just walk in the back of the courthouse without having to go through.
Okay,
their
that's how
gates.
they're doing Carroll County.
Yeah, right.
Easier.
Right, yeah. That's right. So, I actually have a case in Carroll County right now. Yeah.
Oh, judge.
Judge Simpson.
Okay, oh my God, I can't believe he's still on the bench.
Yeah, so you used to work out there?
I did, that's when I got out of law school.
PD's office or DA's office?
PD's
PD's office. Yeah. So did you live here and work out there?
I did, I drove back and forth.
It's not that bad of a drive.
No, it
You're
wasn't.
mostly going against traffic.
Exactly, it was a reverse commute.
Right, yeah, especially if you live in town here.
Right.
Or going out that way, going out I-20.
Exactly.
Yeah.
It was pretty much a straight shot
Yeah.
until you have to get off and exit.
Then that gets
Slows you
a
down.
little long. Start driving along that. But all in all, I don't mind working in that district. That district is so big. If you ask me, it's huge, geographically, it's enormous, you know, because isn't that the one that has like Troup County, Coweta County, Carroll County, and then there's other like little counties, I don't know what they are. But I think each one of those counties is big enough to be like its own judicial district. You know, they've got like 6 superior court judges out there. So why not break all that up instead of making everybody drive around? I don't understand. It doesn't make any sense. Yeah.
Yeah, no, they have, I remember that we used to have, arraignment calendars of like over 100 people. And I'm like, this is insane.
Right.
Like, yeah, it's a big,
Yeah.
they're very busy calendar.
Yeah.
Who's your ADA? I feel like all the ones that I worked with are like lost now.
I can picture them, but I can't remember. I think his first name is Bill.
I don't know, I was saying
Let me
that,
see.
she uploads.
Trying to remember who's out there.
First page does not upload.
Oh, I have one. Remember we went out there by the name, first name is Sarah.
Sarah DeBoer?
Yeah.
I think she's.
I don't know.
Okay.
She and I got along with each other really
I've
well.
heard like good things about her.
Yeah.
I'm not working sure.
Uploads those. First page of the entitlement.
Anyway, I've also got one in Troup County right now, that murder case. That guy, it's a felony murder, so, he sold a girl, young woman, fentanyl, allegedly. They searched his house, they found fentanyl in his house. The woman that he sold it to, gave it to her friend, and the friend died from an overdose. So it's one of those felony murder types of cases. It'd be interesting, I mean, it'd be interesting to see what a Troup County jury would do with that.
I was about to say that. And which judge is on the rotation?
That's Hightower.
Oh, okay.
You know him?
Oh, yeah.
Yeah.
So when I started out, I was in Hightower and Simpson.
Uh-huh.
I was swapped and I was in Watson. And then I had to do a little bit of Henry. But when my last few months were with Blackburn.
So that's how they divide it up there. So like wherever Blackman is sitting, that's where you have to go. So he's like, I don't know if his upstate county.
I don't know. I think it's true. It's Meriwether.
Meriwether, that's the one that I couldn't come up with.
There's another one though that I like never can remember.
I think it's where Thomas is.
Yeah.
You know what? I've got it right here. Let's see.
Let's try to handle on this. And if you have any questions, text me, just do a quiet phone call.
So the Coweta Judicial Circuit includes Carroll, Coweta, Heard. I've never been to Heard. I have no idea. where
I only work there, like, don't know this.
Meriwether, which I have actually been to Meriwether. And like in one case, in fact, it was with somebody who now works or had worked for the Phillips DA's office, Laura Allman.
Oh my gosh, I remember, yeah. She was in that circuit.
Yeah, right, right.
Oh my gosh.
Is she in your office still, Laura Allman?
Yeah, she is.
Yeah, I was
seen
gonna
her
say,
on
there's
Zoom.
so many attorneys. I believe that's right, yeah. Yeah, so we were just talking about, she used to work in the Coweta Judicial Circuit,
Oh, wow.
which is like these 5 counties, like Carroll County, Coweta County, Troup County, which is almost Alabama, basically. So, I actually have a map. I subscribe to this it's publication called Mariposa. And it's really useful. It gives you like every judge's and phone number and like all the email addresses for like their assistants, law clerks. And it gives like it has every hospital in the state of Georgia, every prison in the state of Georgia, every insurance company that is authorized to do business in the state of Georgia has like all their information on it. It costs me like $80 a year. So this is, yeah, it is really cool. Here's the Coweta Judicial Circuit. So it's number 16 right there. You see that?
Oh, my goodness.
I mean,
It's
look at how
huge.
huge that,
That is
that's gotta
huge.
be like, from here now to here, it's 100 miles,
Dang.
right?
Yes, it has to be.
Yeah,
Oh, so that's not weird. Okay, didn't even know.
is that right on the
It's
Alabama
like right
border?
there, you're like.
You know, I never think about the fact that Carroll County actually borders right up, it does
Right,
really border
yeah.
right up on Alabama.
It's, yep, exactly what you're talking about. That's why they get to pieces.
Are we able to do anything with Mr. Ransom or Mr. Brown? Or do you all need more time?
Judge, with Mr. Ransom, for today's purposes, we're just going to waive arraignment and plead not guilty.
Okay.
As far as the bond hearing, sorry, Ms.
Ms.
Charles.
Charles.
Ms. Charles has asked for a week to speak with the victim. I did just file the bond motion last week, so I think that's imminently fair.
Mhm.
So I'll get with Ms. Nelson to get a new court date for that. Do we need to bring Mr. Ransom out for that?
We will. And I probably shouldn't be out here because I guess the deputies are downstairs. They're bringing Mr. Reed up. So we'll figure that out. What about Mr. Brown?
So it'll be the same announcement, with arraignment, plead not guilty. I have spoken to Ms. Charles. The Green Diamond attorney from our office and gotten them into the program. So Ms. Charles and I just need to do a little bit more work on that, and then we'll be able to resolve both the cases.
Okay. I just came out, so we're all good. Is Mr. Reed up now? Great. Why don't we bring Mr. Ransom out first, and then we'll bring Mr. Reed, and then we can do Brown. So Ransom first, please. Whenever you guys are ready. Yeah.
Oh, there is a waiver of arraignment.
Oh, you can have that one.
Thanks.
Yeah.
Okay, all right, so we'll check that out. Yes.
Remember her from before, so just have her come up. Thanks. We're going to start with Mr. Ransom, please. Mr. Ransom, come on up to the podium. Be there with Mr. Melnick, please. So, Mr. Ransom, your lawyer, Mr. Melnick, was talking with the prosecutor, Ms. Charles, because I know Mr. Melnick filed a motion on your behalf to reduce your bond. And we're going to hear that. We're not going to be able to hear it today because the state is entitled to give notice to the alleged victim, and there's an alleged victim in your case. That person has a right to be heard on the question of bond as well. But that just means we'll try to get you back here early next week, whenever we can get you here or get you virtually and get Mr. Melnick plugged in to talk about bond. But in the meantime, we're going to move your case forward. Mr. Melnick is filling out right now a waiver of arraignment, which is the way you're entering your plea of not guilty at this time. That requires then Ms. Charles to get to Mr. Melnick all your discovery. So police reports, I don't know what else there is, if there are videos, who knows what. Ms. Charles knows. She'll get that to Mr. Melnick, and then he will be able to sit down with you and say, here's what the case looks like for the state. It's not so good for the state, or it's not so good for you. I don't know anything about it. I just know what the allegations are. I will see you soon, though, because we are going to talk about reducing your bond. It doesn't mean I will do it, but I will certainly listen to Mr. Melnick, who will argue persuasively that the number ought to come down. You have another case. It's unindicted, but it's like a loitering, you have a bond on it. You have a bond on it. So
He has a bond.
it's not holding you in, but it's like a loitering and something else.
It was giving false obstruction. That's
Obstruction,
that's-
but it's somehow it's felony obstruction, at least as arrested. So I'm just letting you know that that's rattling around out there. That's not why you're in. You're in because you either have no bond in this case or because it's a motion to reduce bond. My guess is just it's a dollar amount that you cannot make. So we'll see you soon to talk about that. In the meantime, Ms. Charles will start getting discovery to Mr. Melnick in this case, and we'll go from there. Ms. Charles, anything else in the ransom matters?
No, Your Honor.
Mr. Melnick?
Not at this time, Judge.
Did you have any questions for me, Mr. Ransom?
No, sir, I just want to say good morning to the court and to you, Judge.
Good morning.
Mr. McBurney. I'm sorry for,
That's okay, you don't say anything.
for the charges that I'm accused of. And I know there's some very serious charges and that I'm not guilty of these charges, Your Honor, and I have a real bad drug problem.
Okay.
Let's stop.
Well, we'll stop there. Mr. Melnick is in fact, by filling out that piece of paper, is saying you say not guilty.
Yes, sir.
And we're gonna go from there, okay?
So, yes, sir.
All right, thank you.
Thank you, man. Thank you.
We'll talk, man. I'll trade you. That's the revocation order.
Thank you.
This is vaguely legible, but hopefully we can make this out.
Who would you like?
Mr. Reed, please.
So we'll let you know.
How are you? Hey, Mr. Reed, you can come right up to the podium.
All right, Judge, see ya.
Thanks for coming by. Good morning.
Good morning.
How you been?
I'm working it out.
How is Cobb County Jail?
Bad.
Bad? I heard it's better food than at Rice Street.
All of it nasty.
No? Okay. Well, you want to get out. I want to give you an update. The state has indicted some of your open charges. You and a gentleman by the name of Zachary Owens were indicted for some burglaries and a criminal damage to property, second degree. Mr. Owens was here earlier. He waived arraignment. No, he didn't. He needs a lawyer. He's going to come back. But your lawyer, Mr. Bridges, already filled out all the paperwork he needs to that waives arraignment. So Ms. Charles, who's now, you've been through several prosecutors, who's now the prosecutor on your cases, will be getting discovery to Mr. Bridges, and we will move forward with all these. It's 1, 2, 3, 4, 5, nope, 4 indictments. I thought we had now covered everything, but Mr. Bridges pointed out that there are still maybe a few alleged burglaries that have not been indicted yet. That doesn't mean we can't move forward with these other cases, but Mr. Bridges will be talking with you about that. He and you may decide, you know what, those will, whatever happens with them will happen with them. Let's deal with all these other cases that have been indicted so that something can happen with them now. But he will come talk to you about what to do with that. I've asked Ms. Charles to figure out if the state is going to do anything with those unindicted burglaries. I expressed some confusion as to how they'd indict some of them, but not the others. And the only thing I could come up with, but I'm just guessing, was that the ones they indicted, because there's some connection with you and Owens, then that was a little package and they indicted that. But maybe these other ones, they don't think Owens has anything to do with. I don't know, and you shouldn't comment on that. I'm just letting you know, I'm trying to figure out how we can sort out those last few that have not been indicted. But Ms. Charles has taken that on as a project, and she's going to figure that out and let me know you need to look this way, and let Mr. Bridges, your lawyer, know. He even plugged in earlier today. Your family got to hear him, but he did what he needed to do by filing some paperwork on your behalf a couple days ago. So I did some talking. Tell me what's going on with you.
Yeah, them unindicted cases, them not me.
Okay. Well, maybe that's why the state didn't indict him, but Ms. Charles is going to take a look at them, and she's got two options. They can just dismiss them, or they can indict them. And if they indict them, you know where they're coming. They're coming to me, and Mr. Bridges will handle them for you. And he may sit down with Ms. Charles and say, let's look at the cameras. That's not Mr. Reed. This is a dark-skinned guy, or it's a guy with pink hair, or it's a woman, or whatever the deal is. So, but until they are indicted, There's nothing Mr. Bridges can do with them, but he can now get to work on all this other stuff, which is what I've asked everyone to do. I'll hear from you guys in a second. So I just want to give you that update that that's what's going on. So, and you, I don't know how long you'll be in Cobb. They move some folks in theory off the floors at Rice Street to Cobb. And I don't know how fluid that is. If you're in Cobb for a few weeks, then you're back in Rice Street, but it didn't have anything to do with your cases. It's just trying to get people into cells rather than on the floor. Okay. All right. So why don't you stay right there? You need to keep looking at me. I'm going to hear from one of the folks who are here, but that phone needs to stop ringing.
Okay.
All right.
Okay, hi.
Good morning again.
Shalom and blessings, attorney. Judge McBurney. Okay, I'm a little nervous, so
Don't worry about it.
I'm read. Quasi attorney Bridges had a date for May 22nd, and it's now been pushed back to July 22nd as of today. And when he went to visit Quasi on Friday, Quasi didn't have a full understanding of the waiver that he had because he contacted me. And there's the communication at Cobb County is like none, it's very little with family as well as with the attorney. So we wanted to get Quasi a private attorney and dismiss the public offender. But Quasi had a question when I asked him that, because he didn't want his case to start all the way over from the beginning, but wanted to have it to start where it was to continue on. And I had a question about that because we did want to dismiss the public offender and hire a private attorney. Is there a possibility that private attorney can request for a court date to be sooner, having all the information, or do the case have to start all back over again? Because he didn't want to keep pushing it back and back. And today it was pushed back. And then today when the attorney came on the Zoom, what he shared with us was different from what he discussed with Quasi on Friday. So we want to move forward with that, but we want Quasi to have that understanding so that he would put that request in.
Okay, so you asked a bunch of good questions. Number one answer is Mr. Reed can have any attorney that he can afford. We will make sure he always has an attorney because these are serious charges. And as you know, there are a lot of them. So he needs an attorney. He can always decide he wants to represent himself. That's a bad choice. And that's not what you're saying. You want him to have an attorney as well. So Mr. Bridges is the attorney who's been appointed, so free of charge. He's a great lawyer. You're not having to pay for that. But if you, on behalf of Mr. Reed, choose to hire someone, you can do that at any time. That person would file an entry of appearance and then would become the official attorney of record. Mr. Bridges would hand over all his paperwork to that lawyer, and Ms. Charles, going forward, would be communicating with the new lawyer. It would not slow things down other than to the extent that that new lawyer said, you know what, I need a couple days just to read all this stuff, but I don't reset anything. Mr. Reed has now waived arraignment for these new charges, which simply means he pled not guilty and is saying, now give me the discovery. So that is a meaningful way to move the case forward. We wouldn't have to do that again. We wouldn't have to bring Mr. Reed back for the 2018 case or the 2019 case. That's already where it is. It just would slide over from Mr. Bridges to the lawyer that you all hire, and then that person will move at whatever pace you negotiate with that person. So it's a slightly different relationship. You're now paying for it. So you're able to tell the lawyer, hey, I paid you, you need to make this happen. Mr. Bridges is a good lawyer and works hard, but he's got a lot of clients because he is doing this because the state appoints him. That doesn't mean he doesn't.
It's been pushed back as of today to July 12th now from May 20th.
You see, I don't know what you mean by pushback. Like let's just take this new case, this new one. There's no next date. Nothing's been pushed back. Maybe on an old case, something's been pushed back, but I'm here to tell you, as the one who controls the cases, nothing is pushed back. There is this new case, and now either you all are going to get a lawyer for Mr. Reed, and that's who Ms. Charles will talk with. But there'll be a scheduling order that comes out, and that's going to have some deadlines that say, Ms. Charles, government, you've got this many days to give discovery to whoever the lawyer is. And then there'll be a deadline. For now, it'll be Mr. Bridges to file any motions if he thinks that, oh, you know what, that was a bad arrest, or the police interviewed Mr. Reed, but they didn't read him his rights. He can file those motions. He knows how to do that, and he knows how to argue them. He does that well. But he may look at the discovery and say, there's nothing here that we need to work with on that side. All right, I don't know who that was. That's where we are. It's going to go as quickly as you bring someone on board, that person can get involved. Obviously, that's a discussion you'll want to have with Mr. Reed, and he needs to have a good relationship with that lawyer. So it may be that they need to connect. But I'm giving you a very long answer. At any point in this process, you could bring a new lawyer in. And then I would relieve Mr. Bridges. He'd go off and do other things. And that new lawyer would become Mr. Reed's lawyer.
And that exchange, how long does that take? Is that a length of time to do that, or is that?
No, I mean, the thing that would trigger it is that new lawyer would file what we call an entry of appearance. It's just a single piece of paper saying, I, Steve Smith, am now Mr. Reed's lawyer. He'd need to file it in all the cases. And that would trigger, then Mr. Bridges would say, I guess I'm done. I've been replaced. And he would give the paperwork that he has collected from the prosecution to Steve Smith, whoever that lawyer is. Okay?
We didn't have a chance to talk to Quincy. I know we can talk to him or not.
Yeah, we can't do that here, but we need to get him going. Did you have a question, ma'am?
Yes, Judge McBurney. I'm Crisis grandmother. We have been here since day one. You have been here since day one.
We've been together.
Yes, sir. And what I don't understand is from the beginning that you told Mr. Bridges, you told him to contact us, call us, do something. Mr. Bridges haven't did anything. I spoke to Mr. Bridges once in a year and a half.
Yeah, you've shared that with me before. I hear you, and I am feeling your frustration, and that may be a reason why, as a family, you choose to hire someone. And you may find that with a different lawyer, you're able to communicate more regularly.
Can we keep you as a judge?
I don't go anywhere. I will be here. I will handle Mr. Reed's cases. The people who would make me go away would be the general public. There'll be an election this year, and if I get voted out of office, then there'll be a new judge. But if I don't get voted out of office, then I'm here till we resolve Mr. Reed's cases, okay?
Okay, because they was going to send him to someone else, and I wanted to keep you because you've been here from day one.
Okay, well, I appreciate that. I don't plan on going anywhere, but that's for the voters of Fulton County to decide. Mr. Reed, did you have any questions?
Yeah, that 2018 case, it's like intent to distribute. That was like a joint of weed. I think it was like a lot of weed and stuff. It was just a joint.
Okay, well, again, that's the kind of thing that you and either Mr. Bridges or the lawyer that you're I'm pulling up the case now. That's something that they'd want to talk about. It is 2 drug charges, a little one, a misdemeanor marijuana one, and then a more serious one. But
no, the more serious one was a joint.
Okay, it may be, and you and your lawyer should talk about that, and then your lawyer will talk with Ms. Charles, and it may be that the state's not really concerned about that case from 2018, but then of course you got one from 2019, and now 2 2021 cases, and then we got to figure out about these unindicted robberies, which you're saying they weren't you. So you got a lot of moving parts out there, and it's going to make sense to figure out once and for all. This is our lawyer. It's Mr. Bridges, or it's whoever you all bring on board, and we will welcome that person, get that person up to speed, and see what we can do. Okay? It's good seeing you. You stay safe. So, Ms. Charles, I will have Ms. Nelson bug you in a couple weeks about what's going on with the last few unindicted charges for Mr. Reed. just so we can get closure on that. And if you could just give us the, yes, we're going to indict, and I know you don't control when, or you know what, I've looked at them and we're not going anywhere. Take care. Does that make sense?
And Mr. Durant, yes, Sharon.
Okay.
Yeah, we should do the last one.
Mr. Corporal, Mike, you want to bring up Mr. Brown, please, last one?
He's the last one. I'm ready for him.
All right.
The court would like that.
And Judge, after that, I have an off-calendar matter for Rachel, but she just stayed long.
Okay.
It's about Santana Phillips from Friday's calendar.
Yeah.
There was an issue with the jail records, so I told Ms. Charles a little bit about this. We just need the court's guidance.
Okay. Is she not going to BHTC? I signed some paperwork.
That's right. That's what we're trying to do, and jail records is not an agreement.
Okay. All right. Mr. Brown, take a seat next to Ms. Wood, please.
All right. Good to see you again.
Mr. Brown, I'm Judge McBurney, and you have new charges with me. You have an older case from non-complex that got transferred to me. I just asked that they send it so that you can have one lawyer, one judge to work through everything, whatever it is we do. Ms. Wood had talked with the prosecutor a little bit to see if there was something we could do to move your case forward today. It sounds like we're not quite there. But in the meantime, as I understand it, Ms. Wood is going to waive arraignment for you, which is basically she's entering a not guilty plea for you in this new case. And then Ms. Charles, the prosecutor, will get discovery to your lawyer so you guys can look at what kind of evidence the state has, and we'll move it forward. All right? Ms. Wood, anything else in Mr. Brown's cases?
No, Judge, just that we are working on a resolution, and he has been accepted into a program, so just to, so you know what we talked about at the jail, and what the prosecutor and I talked about. If we cannot resolve those globally, then I'll just file the bond motion and we'll go from there.
Okay. What's the program?
It's called ASAP Cares, and that is what Mr. Charles and I need a little bit more time. The pre-indictment attorney had done a little bit of legwork, and so we just kind of need to.
Pre-indictment on the state side.
So from, sorry, Judge, our pre-indictment.
You're a pre-indictment person.
Complex, they have a new name in there.
Sure.
She had sent me the acceptance letter, and so I was trying to do a little bit.
Got it. You and Ms. Charles need to be comfortable that this is something that makes sense.
Yes.
Okay, got it. So Mr. Brown, we will not forget about you. I'll enter a scheduling order that will keep the case moving. But those are deadlines. Anything can happen before then. So I'll hear from you in a second. But if Ms. Wood is able to get with Ms. Charles and they agree this is a good program and you're still admitted in and they want to, you want to bring it in as a plea, we'll do that. You won't have to wait for these deadlines in the order that I set. But it sounds like everyone needs a little more time to digest this ASAP Cares, whatever it was called. Does that make sense?
Initially, I thought this was like some type of stipulation of the bond that I have right now, because for some odd reason, my bond is like still the same amount, and I've had excessive charges dropped. So I only have 2 charges, and the last courtroom that I was in, I was told that I'm supposed to find a if I was to find a program that I will be able to, I guess, bond out directly to the program.
Mm-hmm.
So she said something like we were going for a consent bond to the program directly.
Okay. And sometimes that's how things work out. It doesn't always happen that often once you've been indicted, but I'm looking at your bond now. You got a $75,000 good bond with an ankle monitor, but to your point, 35,000 of that was on an aggravated battery charge that didn't, oh, wait a minute. Am I looking at the right case? 180174.
That's right.
Yeah, that all got dropped. The aggravated battery got dropped. The only things that moved forward were the ag assault and the gun, which says to me that the bond really should now be at 40 rather than 75, because there is no more count 5, if you will, of the complaint. The Judge Borski, who set that $75,000 bond, I don't think that the count 5 fits anymore. So I'm fine fixing that. I don't know if you can make a $40,000 bond, but this isn't so much about you making a bond and disappearing as it is, let's get a good program.
Because she said technically, Your Honor, that I'm supposed to get a reduction if I was to actually find a program, and I got accepted into the program, so I'm trying to figure out like.
This is what Ms. Wood is working on. Yeah, so I need to be okay with the program, not Judge Borski. And if Ms. Wood only knows the name of the program and nothing more, she's not going to be able to answer many questions like how long does it last? Is it certified? What do they do with probation or pretrial services? I'm gonna have a lot of questions before I say, look at this, you were charged with aggravated assault and a gun, and I'm just gonna let you out. So.
I understand that, sir.
So, yes, so that's what we're gonna work on, and then we'll, get you back into the judgment.
I have a question also. Well, she was talking about, basically like a reduction or something like that. Is there any way that that will be able to happen today?
Not today, but what Ms. Wood, your lawyer, may do on your behalf if after Ms. Charles looks at this and says, you know what, I'm not so excited about this program. Ms. Wood may say, you know what, I thought we'd get in this program. The state's not so interested, so we'd like to argue for a bond reduction. We do those all the time. The gentleman who was out here just before, well, 2 before you, is going to argue for a bond reduction. Not today because they have to get the victim here, but he'll be back next week. So what you need to do, and I promise I'll let you finish, you need to let Ms. Wood get a minute to get up to speed with your case. You've got lots of good ideas, but Ms. Wood needs to be able to advocate for you because I'm going to start asking questions and you can answer some of them because you know your case best of all, but there are going to be some legal answers and Ms. Wood needs to be able to give those for you on your behalf. So give her a few days to get up to speed and then you two can talk about, well, wait a minute, do we want this program? Do we want a bond reduction? Should this be a plea? Should we do all sorts of things are out there. But today, what we're focused on is waiving arraignment. It sounds like it's going to happen. Getting you discovery in the case. So Ms. Charles needs to hand over the police report if there's body cam, all that kind of stuff. Then Ms. Wood can say, all right, what makes the most sense? And get your thoughts about what you want most. And she'll say, here's how we argue for that. Or she may say, you don't want to do that with Judge McBurney. That's not going to go well. She knows that situation.
So I have one more question. So if I was to resolve my case today with the program, would that be an option also?
So it would in theory if the state was ready to move forward, but Ms. Charles needs a chance to understand what this program is. There's an alleged victim in your case. I don't know the facts of your case, but the allegation is you shot someone or you waved a gun at someone about you a gun and someone who was on the receiving end of it. That someone on the receiving end has a right under Georgia law to be told what's going on. So Ms. Charles would be able to say, I like this plan, let's do it, but I got to talk to Fred Jones, the guy that you supposedly did something to. And Fred Jones doesn't have to agree, but he has to be given a chance to say, I think that's a great idea or a terrible idea. Ms. Charles will tell me, so you know what? Victim thinks this is terrible. Okay, I've heard that. Maybe that's persuasive to me. Maybe I understand why Fred Jones isn't happy. Well, let's get you some help. Let's get you in a program. We'll see what happens. So no, today is not the day things are going to sort out. Ms. Wood needs a little more time to be able to be persuasive with Ms. Charles. Ms. Charles needs some more time to understand, hey, is this a good fit or not? Okay?
I have one more question.
You always have one more question. This is your last question for today.
Will the program still be prevalent if I just make bond today?
So you're not making bond today. And along with Judge Borski, I would be keen on you getting into a program rather than just hitting the streets. So this notion of, hey, Judge, how about like I just make bond? Now, if you post bond, I'm not taking away your bond. You haven't done anything that says to me you shouldn't have a bond. You've got a bond in the system. So if you got a special someone on the outside who's playing the lottery and that special someone wins 75 grand, you're out. There you go.
Okay.
That was your last question. You can ask Ms. Wood other questions.
How about 4,000?
It is right now 75 grand, but I'm gonna modify it to get rid of the 35 grand that was on count 5.
Okay, so it's 4,000?
40. Yeah, add another 0.
Okay, no problem. Thank you.
All right.
You have a nice day.
Did you say, Ms. Wood, this is your case or you're covering it for Ms. Patel? Mr. Brown? Yeah. All right. Well, good luck.
Thank you.
Come with answers. All right. So we're done with the calendar. You've got one off-calendar thing you want to talk about.
It should be brief.
Okay. Well, let me just Ms. Rivers can go. We don't need, whatever we're talking about, she doesn't need to take down. Okay. Thanks, Ms. Rivers. All right. So what case?
So it's Santana Phillips.
Oh, right, Ms. Phillips, who was on last week.
Yes, Judge.
Okay.
So Ms. Patel is out of the state and she called me yesterday. There's a whole thread of emails between her and Ms. Bordes and all of BHTC and the jail records. So we checked the bond order and everything. For whatever reason, jail records is relying on the citations that came in at the time of arrest, even those were never like brought through the complaint room. So they're telling Ms. Patel that they cannot release Ms. Phillips until there's a bond on those charges. And so
Can you give me the case number, please?
yes, sorry. Let's see, the case number it's 21 CP.
It's a CP case, Ms. Phillips was, or she had
We had the SC and then.
so the hangup is the CP case. So just remind me, I'm not remembering enough about it. Did Ms. Phillips enter a plea or she would be a track 1 into BHTC on her SC case?
I'm 98% positive it's a track 1.
We would have to, because I don't think she took a plea.
Yeah, I think I'm
Okay.
pretty sure it's a track 1, but I can double check.
But the hangup is not the SC case, it's the CP.
Yes.
Okay, so the CP number is?
It's 21 CP 203128.
Okay.
So.
So her current booking number, they've got her in on 4 counts, 2 cruelties and 2 child endangerments. Is that the issue?
Yes, Judge, and when you look under the documents tab, you'll see that electronic warrant and citations. I think this is what they're basing that off of. There are only 2 arrest warrants included, but there's a double citation.
Which is why everything is double.
I have no idea.
Okay.
Yes.
Well, but they're different numbers. The citations are all different numbers. So it is in fact, well, it's lots of counts. So how do we fix it?
That is my question to the court, if the court has any ideas. Usually when we have these issues pop up, it just takes us sending the bond orders to jail records and them understanding that those other charges never made it into the complaint room or the complaint room declined them.
So the bond that Judge Oliver signed in September of last year, that is a UJR, it just says 1 and 2 because those are the 2 counts that are in the complaint. But the jail is saying there's some other counts that the state hasn't NPGJ'd that need a bond.
Correct.
All right.
Let's see the other counts in Odyssey.
Yes, there are none.
There are none.
No, I hear you, but I'm also seeing that there's a zillion citations in there. So this seems like a Is there, I think Ms. Phillips is supposed to go tomorrow. I'd like her to be released tomorrow. So Ms. Nelson is suggesting the state NPJ the other charges, but I don't know what will happen faster. I also could enter a revised bond if the jail says we see 6 counts or 4 counts. Great, then here's a bond. As long as you can do a UJR on cruelty in the second. People have been kind of loosey-goosey about that. How do NPGJs work on your side? Are you able to do that, Ms. Charles? Is that something where you have to get blessing from on high?
I can go ahead and do it if I can see it in Odyssey, but I don't even see it.
But I don't know how you could do it if you don't see the charges in there.
That's weird.
Forwarded to me from Mr. Hutcherson. I think he might be involved in the intake unit.
Okay, so it might be an intake. I see the other fact. I'm considering decline the certificate, but will consider tax information once it's gathered to stay back in a week. So I can reach out to Kenny and see.
Okay, that'd be so helpful.
Because he was gonna decline it.
Right,
Then
that would
that
solve
would
the
have solved the
whole
whole thing.
Right.
All right, let me see that. Can you forward that email to me,
Yes,
please?
yes.
All right, let me just check.
And that would be, I'm reach out to Siri as well.
What is it?
So I reach out to Siri as well.
Okay.
And see.
I'll send you this over.
Yeah, cruelty in the second can be a UJR. So why don't we do this?
Easier.
I offer my services up. If is that, do you all know who in the jail Ms. Nelson should reach out to, or is it Ms. Vortis? I'm happy to rely on, they're both fantastic litigation managers, but I'll just do a amended bond order that pushes UJR across all the counts if they are all just more cruelties and child endangerments, because I'm looking at the UJR statute and those crimes are not yet swept up in the prohibition against UJR.
That might be the easiest one.
Yes.
Is to have it pushed on all accounts.
Okay.
As opposed to get Kenny, get CAC, and kind of deal it out.
Is that the easier approach?
And that's the easiest approach. Just to
Okay.
sweep it all
All right. Well, we'll do that. Anything else I can do for you?
No.
Thank you so
Thank
much.
you.
Okay.
That's really-
Let me make sure I'm not overcommitting. Nope, I'm good. I got time for that. And I was able to bookmark UJR in my book. Find it. I was like, hey, how about a signature bond for this murder defendant? I'm pretty sure that's not included. All right, Ms. Charles, anything else?
No, Your Honor, that's all for me today.
We've got Ms. Nelson, have we nailed down yet when Mr. Oddie and crew are going to be here?
I was just working on an email. I think we're gonna go for Friday. I just need to make sure the defense is okay for that day.
Okay, so Ms. Charles, there is a defendant, last name Oddie,
Saw that
O-T-T.
this morning.
Yeah, so we have maybe about a dozen, hopefully less. These are folks who have been determined not competent. It's the 3 nots, not competent, not restorable, not another thing where them being not is not helpful. And so they have been sent to DBHDD where they, I won't say languish because they're getting care and treatment, but literally for years. Mr. Ati's case is now 8-9 years old, charged with aggravated assault against a family member. DBHDD has said, we're done. clinically, we can't keep him anymore. He's doing fine. And so he's going to be released from the group home where he is. What that would mean technically is released to the custody of the sheriff. You go back into custody. I don't think that's a good idea from what I've heard, but of course I need to hear from the state. What I need you to do is to think long and hard about what realistically is going to happen with this case. Medical professionals have said he's not restorable. He's not competent. So you can't try the guy. It's not murder. It's not rape. It was something maybe serious at the time. Don't know. You're going to need to dredge up the file, but we will have this emergency hearing. Mr. Ati has a lawyer who is going to advocate for something. My primary question won't be for her. It will be for you or whoever comes from the district attorney's office of, isn't this something that maybe by now should be dismissed? It's 9 years old and I have no idea. It may be that there's a victim who's missing his arm because Mr. Ati chopped it off and that person would say, no, I'm not interested in